forces good doctors out of the practice of medicine. Mr. Chairman, let's support a bill that is so strongly endorsed by the American people. Now reserve the balance of my time.
The gentleman reserves the balance of his time. The gentleman from Michigan is recognized.
Mr. Speaker, I am now pleased to recognize a senior member of the House Judiciary Committee, Gerald Nadler, who has worked on this subject matter for quite a long time, and I would yield to him as much time as he may consume.
The gentleman is recognized for 2 minutes.
I thank the gentleman for yielding, and I rise in opposition to this deeply flawed and deceptively named legislation. Contrary to the bill's title, this bill will not promote access to better health care, nor will make health care more affordable. If the wishes of many of the proponents of this legislation come true, and the Affordable Health Care Act is repealed, and Medicare and Medicaid as we know them are curtailed or eliminated, then decent affordable health care will remain out of reach for millions of Americans, including many who now have access to health care services. I urge all members to keep one fact in mind as we debate the medical malpractice aspects of this bill. These provisions would apply only to people who had meritorious claims of malpractice against them. You don't have to limit people's recoveries or attorneys' fees for people without meritorious claims. So whatever we're doing here today will be done only to those who have been injured, whose injury has been inflicted by someone else's wrongdoing, and who need and should be entitled to compensation. The argument we hear, which is not a new one, is that if we allow the players in the healthcare industry, including Big Pharma, the manufacturers of defective medical devices, and even big insurance companies and HMOs that routinely refuse to pay for necessary healthcare services, if we allow them to escape the consequences of the harm they inflict, then somehow we'll all be better off. This is not true, has never been true, and despite the extravagant claims of the proponents of this bill and the industry's lobbying for it, that will not be true if this multi-billion-dollar gift to bad actors in the healthcare industry were to become law. Just how pricey a gift to industry are we talking about here? According to the Congressional Budget Office, $45.5 billion over the next decade. Now, anyone who believes that those savings will be passed along directly to consumers or to healthcare providers and victims of medical malpractice is living in a dream world. Some of us will remember the debates we had in this House for the 8 years preceding enactment in 2005 of the Bankruptcy Code rewrite. We'll no doubt remember the argument that abuse of the bankruptcy system was a hidden tax of $400 per year for every American, and that tightening the rules would be in the interest of all consumers. Well, we passed that huge giveaway to the big banks. Consumers have not seen a nickel of that $400. The banks pocketed all the money. If you think that this bill will lower costs for consumers, that the big insurance companies will not simply pocket the money, there's a famous bridge in my district that I might be willing to sell to you. So keep in mind just who will be bearing the burden of this legislation. People who are subject to limitations on damages and on their inability to obtain competent counsel. Something not imposed on insurance companies or drug companies or HMOs. That may be good for the insurance companies, for the manufacturers of defective drugs and medical devices, and all the other wrongdoers walking these halls with open checkbooks, but it will come at the expense of their victims. Nowhere does CBO or the sponsors explain why they believe that insurance companies, big pharma, medical device manufacturers will pass any savings along. Nor do they account for the cost of the care needed by people who have been injured and who will be unable to receive adequate compensation. The gentleman from this bill is not limited to suits against individual health care service providers, for doctors and other licensed health care professionals. It would provide protection against malpractice claims for large corporations, insurance companies, health maintenance organizations, and pharmaceutical giants when they deal in defective products or if someone else's health is destroyed because an insurance company refused to pay for necessary care. Mr. Speaker, we heard the gentleman from California refer to the California legislation that is the model for this legislation passed in 1976, 36 years ago. That legislation enacted a limit It said for non-economic damages, you can only get a recovery of $250,000 because you lost a leg or they removed the wrong leg or whatever. They felt in 1976 that $250,000 was an appropriate amount to limit it to. Today, in today's dollars, that's $38,000. But there's no inflator in that legislation. There's no inflator in this legislation. If that $250,000 in 1976 today is $1.4 million. So if we were modeling this on that, we should say the limit is $1.4 million. But we're not doing that. We're saying $250,000, and we're not putting an inflation adjustment in here. So it'll be $250,000 this year, and 5 years from now it'll be the equivalent to $100,000, and 10 years from now $35,000, and eventually zero. I submit that it is very wrong. It may be that if malpractice causes a woman to lose her fertility, or causes her to lose the ability to bear children, the medical costs to her may be minor. Lost wages, economic damages may be minor, but the inability to bear a child, that should be limited to $250,000 and eventually to almost nothing because there's no inflation in this. If someone is put in a wheelchair for life, the pain and suffering is worth almost nothing. That's what is wrong with this legislation. That's what's immoral about this legislation. That's why we ought to vote against this legislation. I yield back.
Gentleman yields back. Gentleman from Texas is recognized.
Mr. Chairman, I'll yield 5 minutes to the gentleman from Illinois, Mr. Johnson.
Gentleman's recognized for 5 minutes.
Mr. Speaker and members of the House, first of all, let me thank the Chairman for his willingness to allow me to speak on an issue in which we do not agree. I appreciate the courtesy. I appreciate the lively debate that has preceded me, and I think probably in a far more articulate way than I'm going to be able to articulate. But let me just, Mr. Speaker and members of the House, address this issue maybe in a bigger sense and then in a specific sense from the standpoint of a Republican member of the United States Congress. To begin with, I believe that this addition is largely unrelated and almost entirely disconnected from the underlying bill. I believe it demonstrates some concern, or I believe it reveals some lack of concern for sensitivity, and I think in a lot of ways reveals a duplicitousness that I think is inherent in an issue, in discussion of this issue. I think it is statist and antithetical to our beliefs, at least my beliefs, and I think most of the members on this side of the aisle, with respect to what America is all about. I look at this from a standpoint of a Republican member and a Republican Party who has been a forerunner, has dealt with the issue of states' rights, and quite frankly has attacked this health care bill, the Attorneys General, on a states' rights and interstate commerce basis. It is a classic example, Mr. Speaker and members of the House, as to what has historically been an area for states' rights. Whether it's the criminal justice or domestic law or civil justice, our founding fathers set in place a federal level and a state level of government, and this strikes at the core of states' rights. In addition to that, Mr. Speaker and members of the House, separation of powers. We have been critical, and I think legitimately from this side of the aisle, with respect to HH waivers that have been granted. We've been critical of the EPA and USDOT and so forth for their administration and their promulgation of rules without legislative authorization. And yet, this entirely desecrates in some ways our whole judicial function. Our whole judicial function by which liability and damages and intrusion into the judicial arena is something that's been sacrosanct, and I think that's essential to our viewpoint of what the Constitution is all about. And it also strikes at the core of our free market system. I, from having been involved, both from a number of standpoints in the law practice and otherwise, see a system that in an overwhelming number of cases works to effect justice. 2 attorneys or more, witnesses, jurors, a judge, and the common law of 200 or 250 years almost inevitably results in just results. And now we have a situation, despite that commitment to free market that we have, where we're now proposing that the federal government dictate an imprimatur to override this whole system that's already in place, and I think infringes on our constitutional right to a trial by jury. And it also strikes, I think, Mr. Speaker and members of the House, at what we Republicans say we believe in terms of individual worth. one of our attacks, quite frankly, on the passage of this bill, which I largely subscribe to, the attacks, are ones that deal with the depersonalization of the individuals inherent in President Obama's health care approach. It is a collectivist, this bill, a collectivist attack on personal realities and a disregard for age, circumstances, state, or community of residence, and I think that addresses in a very serious way the concept that we have constitutional worth of the individual. In conclusion, this bill has essentially nothing to do with revenue production. We all know that. It obfuscates the underlying purposes of the bill, which is, quite frankly, to dismantle the inherent bureaucracy in the health care bill, which I largely subscribe to. It injects politics into a legitimate debate on a substantive public policy and prevents Republican and Democrat members from an up or down vote, and strikes, I think, at our fundamental beliefs of states' rights, of individualism, and on constitutional premises. In summary, I believe that a no vote is a vote to preserve individual dignity. Our no vote is one to maintain constitutional values, and it is to safeguard states' rights and separation of powers. I know this is well intended, but this is not the vehicle to do it in. The vehicle is Austin, Texas, or Albany, New York, or Springfield, Illinois. I have some serious concerns about state legislation that would also interfere with separation of powers, but this is not the arena to do it in. It is not the bill to do it in, and I think, quite frankly, it is one that, unfortunately for me, strikes at the core of why I'm here. I'm not here to dismantle our common law system. I'm not here to dismantle the free market system. I'm not here to dismantle states' rights. I'm here to stand up for what I think the American people sent us here for. I don't think the health care bill was well considered. I think it should be substantially addressed in terms of this and other legislation, but this bill doesn't do it, ladies and gentlemen. And I, with all due respect, ask my colleagues on both sides of the aisle to join with me in a no vote on what I think is maybe well-intended but certainly misdirected effort. And I join with my colleagues over here and some over here in urging a no vote. Thank you.
Gentleman's time has expired.
Mr. Speaker,
Gentleman from Michigan is recognized.
could I ask if the distinguished gentleman from Illinois, Mr. Johnson, would like additional time? If he requires any, I would be glad to arrange to yield him further time.
What was the question? I'm sorry. Oh, you want to know if I want more time?
I said if you require more time, I would be delighted to yield it to you.
Well, you're very kind to do that, Mr. Conyers. I think I probably pretty well addressed it, and I think between myself and my inarticulate comments and your opposition and some opposition over here, I think the debate has been very good and good for the process, and this is what I'm with you on, sir.
Well, I thank you, Mr. Johnson.
Gentleman from Michigan is
Mr.
recognized.
Speaker, I am pleased now to recognize the Judiciary Committee member from Florida who's worked very carefully with us on this subject matter, Ted Deutsch, and I yield him 4 minutes.
Gentleman's recognized for 4 minutes.
Thank you. Thank you, Mr. Chairman. It's no surprise that I'm disappointed with the content of this bill before us today. I join with my colleagues who have expressed their disappointment, but I'm also disappointed with the process behind it. Yesterday, for a totally bogus reason, the Rules Committee declared an amendment I offered out of order. They claimed it would add to the cost of the bill, despite having no numbers. The amendment did not create some new regulation. It did not create new judicial proceedings. It did not set aside money for a new program. Let me tell you what it did do, Mr. Chairman. It would have made a terrible bill slightly better. It's simple. My amendment ensured that doctors who intentionally, not accidentally, but intentionally harm their patients are not exempt from medical malpractice liability. If this Congress wishes to tell a child made blind by the negligence of his doctor that those in this chamber know better than a jury, if my colleagues wish to pretend that the 7th Amendment of the United States Constitution, guaranteeing a trial by jury, was somehow omitted from the Bill of Rights. I disagree, but so be it. The very least we can do is ensure that if a doctor intentionally abuses his patients, that he will not evade justice. Surely, the sponsors of this bill did not intend to extend liability caps to a pediatrician who sexually abused a child, or a dentist who raped his patients under sedation. I'm disgusted to say that those are both real examples of the kind of abhorrent behavior H.R. 5 may mistakenly immunize without clarification. Is it too much to ask that we simply think this through? Can someone explain to me how this amendment costs a penny? Better yet, will someone explain to the 103 children who were molested by a Delaware pediatrician that Washington wants to make it easier for sexual predators to evade justice? My friends, differentiating between medical errors and intentional harm is not some wild and crazy new idea being peddled by the left. Many states, blue states, red states, and in between limit malpractice awards but make distinctions for intentional torts. The majority could have considered my small change and protected the common sense state laws that are already on the books. Instead, under the 112th Congress, relentless partisanship has poisoned this well and impeded our ability to write good laws. Perhaps, Mr. Chairman, perhaps the reason Americans are so disenchanted with Congress is because they know that it doesn't have to be this way. I urge my colleagues to vote no on this legislation, and I yield back the balance of my time.
The gentleman yields back. Gentleman from Texas is recognized.
Mr. Chairman, I yield myself such time as I may consume.
Gentleman's recognized.
Mr. Chairman, lawsuit abuse drives doctors out of their practices. There is a well-documented record of doctors leaving the practice of medicine and hospitals shutting down particular practices that have high liability exposure. This problem has been particularly acute in the fields of OB/GYN and trauma care, as well as in rural areas. The absence of doctors in vital practice areas is at best an inconvenience. At worst, it can have deadly consequences. Hundreds or even thousands of patients may die annually due to a lack of doctors. According to one state study, 38% of physicians have reduced the number of higher-risk procedures they provide, and 28% have reduced the number of higher-risk patients they serve, all out of fear of liability. The American College of Obstetricians and Gynecologists has concluded that the current legal environment continues to deprive women of all ages, especially pregnant women, of their most educated and experienced women's health care providers, end quote. A study from Northwestern University School of Medicine polled residents and found that many wish to leave the state to avoid its hostile malpractice environment. The study concluded that, quote, approximately one-half of graduating Illinois residents and fellows are leaving the state to practice. The medical malpractice liability environment is a major consideration for those that plan to leave Illinois to practice, end quote. Without a uniform law to control health care costs, many states will continue to suffer under doctor shortages. And, Mr. Chairman, I'll reserve the balance of my time.
Gentleman continues to reserve. Gentleman from Michigan is recognized.
Mr. Speaker, I'm pleased now to recognize the distinguished gentleman from Georgia, a member of the House Judiciary Committee, for as much time as he may consume.
Gentleman's recognized for as much time as he may consume.
Thank you, Mr. Chairman, and thank you, Mr. Speaker. Today, Mr. Speaker, I rise in opposition to this harmful bill, H.R. 5, the so-called Protecting Access to Health Care Act. Now, this bill is premised upon what I would call a story, because that's what my mama used to tell me, my mama and my grandmama, as I was growing up, used to say, you know, that's wrong to say that someone is lying. Don't say that. You say that they're telling a story. And so I grew up plagued with the guilt that comes from calling somebody a liar. And I still have that sense of shame, and so associated with that word liar. And I'm not here to accuse anybody of lying, but I will say that H.R. 5, the so-called Protecting Access to Health Care Act, is a story. It's premised on the story that runaway frivolous lawsuits, medical malpractice lawsuits, are a major cause of driving the cost of medical care through the roof. And that's not true. This bill restricts a patient's ability to recover compensation for damages caused by medical negligence, defective products, and irresponsible insurance companies. It also sets a cap of $250,000 for non-economic compensatory damages, which are awarded to victims for emotional pain and suffering, physical impairment, and disfigurement. And I'm so sorry to have not had this photograph blown up. It's a photo of Carolyn Palmer of Marietta, Georgia. Ms. Palmer was in an automobile accident back on March 23rd of 2007. She sustained 2 broken legs, a broken shoulder, abrasions on her arms, and a collapsed lung. While she was at the hospital recuperating, they noticed that her left hand was swollen, dusky blue, and cool to the touch. But after so noting on her medical record, the doctor left work that day, and no further action was taken about that. That was a clear sign that blood was not flowing to that limb, and that something was wrong. Nothing was done, no follow-up. The next day, they found that the IV line had been misplaced in her arm, and they referred her in for some treatments to try to reinvigorate the circulation in that arm. And there was nothing they could do. They tried everything. They even subjected Caroline to a procedure on both arms to relieve the pressure and treat the loss of circulation by producing a large gaping hole in both arms. And that procedure failed, whereupon she then was subjected to the cutting off of her left arm and the cutting off of her right arm. Now, we've talked a lot about, well, how much is a leg worth? How much is a leg worth when you lose a leg? Well, how much are 2 legs worth? How much are 2 arms worth? This picture shows Carolyn Palmer in this horrendous state. And under this amendment, under this bill, H.R. 5, this woman, this victim, would be limited to $250,000 for her pain and suffering and disfigurement. And that's not right. How do you put a cap on someone's pain and suffering? How heartless is it to cap non-economic damages when one has lost a limb, becomes blind? How much is vision worth? How much is the ability to see? How much is that worth? $250,000 under this legislation. If you become paralyzed at the hands of a negligent health care provider, can no longer walk, how much is that worth? $250,000. These caps hurt the most vulnerable among us, children, senior citizens, and working poor. They can't even recover for economic losses, such as lost wages. They may not be working. A child doesn't work. A child left with no arms is limited in non-economic damages to $250,000 for the rest. That's going to handle him. He's got to roll with that for the rest of his life. $250,000. It's not right. Medical malpractice is about real people with real injuries. The Institute of Medicine estimates that 98,000 people die each year in the United States from preventable medical errors. Tort reform proposals such as H.R. 5 fail to address the deaths and injuries associated with preventable medical errors every year. Now, this H.R. 5 is an unholy alliance between two stories. The one story which I just outlined to you, and the other story being the repeal of the 15-person Independent Payment Advisory Board, also known as IPAB, which was created under Romneycare. Oops, I mean Obamacare. Oops, I mean the Affordable Care Act. Now, while I do believe that there are some good reasons to be opposed to the IPAB and to vote to abolish it, I believe there's some good reasons for that, but rationing of medical care is not one of them. Anyone who says that this IPAB board has the power to cut the benefits paid to Medicare recipients has either not read the bill or is telling you a story. Now, just for the record, I want to read 42 U.S.C. Section G 1395 KKK. And I'm not going to comment on the KKK right now, but that's the subsection of 42 U.S.C. Where the law that was passed, Affordable Health Care Act, is stated, the law, 42 U.S.C., and it says the proposal shall not include any recommendation to ration health care, raise revenues, or Medicare beneficiary premiums under Section 1818, 1818A, or 1839. Increase Medicare beneficiary cost sharing, including deductibles, coinsurance, and copayments, or otherwise restrict benefits or modify eligibility criteria. That is what Obamacare, Romneycare, the Affordable Health Care Act provides for. That's the law. Anybody who tells you otherwise is telling you a story. Now, I understand, now I'm going back to the first story, I really oppose it for the reasons that I previously stated. This bill is another example of the Republican majority bringing a partisan bill to the House floor that has virtually no chance of becoming a law. H.R. 5 does not create any jobs or grow the economy. It's a slap in the face also of states' rights, something we've heard that the other side has depended on for a long time. States' rights, the 10th Amendment. H.R. 5, ladies and gentlemen, denies states their right to have their own tort laws. State of Georgia, for instance, in its constitution, says that all citizens are entitled to a jury trial. The legislature imposed a $350,000 cap on non-economic damages in medical malpractice and other cases. Case went up to the Georgia Supreme Court, which ruled that to limit non-economic damages deprives one of their constitutional right to a jury trial. This bill, H.R. 5, would do away with what the Georgia Supreme Court has ruled insofar as Georgia law is concerned, and it's a gross overstepping of federal legislation into the affairs of the state, and I oppose it. And I understand that there was a meeting yesterday, a special called meeting that Majority Leader Eric Cantor called of the Tea Party Republican caucus to kind of tighten some screws and twist some arms to get the caucus to go along with H.R. 5 so that no one would get embarrassed. Now, it's yet to see what will happen, but I believe that all of the Tea Party Republicans will fall into line and vote in favor of H.R. 5, which has absolutely no chance of passing once it goes to the other body. So I want to thank the chairman, ranking member of Judiciary, John Conyers, for giving me this time, and I will yield back the balance.
Gentleman yields back the balance of his time. Gentleman from Texas is recognized.
Mr. Chairman, I'm pleased to yield as much time as he may require to the gentleman from Georgia, Dr. Gingrey, who happens to be the sponsor of the legislation we're considering tonight, the Health Act.
Gentleman is recognized for as much time as he may consume.
Mr. Chairman, I thank the chairman of the Judiciary Committee for yielding to me and the opportunity to follow directly my colleague from Georgia on the other side of the aisle. A number of things were said, and I feel grateful to have the opportunity to address those. One of the comments that the gentleman made, the gentleman is my good friend, and he would agree with that. But in regard to this emergency caucus meeting with the Tea Party caucus on the Republican side with our majority leader, Eric Cantor, I am an original member of the Tea Party caucus in the House of Representatives. If there had been any emergency call meeting, Mr. Chairman, I can assure you that I would have been right there with Michelle Bachmann and Steve King and others, of 20 of us that were original members of the House GOP Tea Party caucus. There was no such meeting. Let me refute that statement, although I greatly respect my friend from Georgia, from DeKalb. In regard to the issue, I'll be glad to yield to my friend.
Yeah, I certainly don't want to misstate what actually happened, and I think I said that it's my understanding that that meeting was held. That's the information that I received.
Reclaiming my time, and the gentleman, he did say that. He said it was his understanding. He didn't state it as a matter of fact, and I appreciate that comment. But Another thing, Mr. Chairman, that I want to address, he talked about, and he named names. I think the lady's name was Ms. Palmer, Marietta, Georgia. I live in Marietta, Georgia, and half of the last 36 years I represent Marietta, Georgia in the 11th Congressional District, and half of the last 9.5 years. And, you know, the description of this unfortunate soul's injuries and the things that happened to her, the broken bones, the collapsed lung, the lack of blood flow to the extremities because of a improper placement of an intravenous line, maybe instead of in a vein in an artery, that resulted in amputations of her upper extremities. You know, these when the general public hears stuff like that, Mr. Chairman, they're horrified and to think that we on this side of the aisle with H.R. 5, the Health Act, which is part of the PATH Act that we are discussing on the floor today, to suggest that a person that suffers like that could only recover $250,000 in non-compensatory pain and suffering is absolutely untrue. The gentleman, my friend from DeKalb, is an attorney. He knows the legal system. He's been in the courtroom. I'm not sure whether he's tried on the side of the plaintiff or the defense in regard to medical malpractice cases, but he clearly knows the difference in non-economic pain and suffering in regard to this particular bill, and on the other hand, recovery for severe losses, medical compensation, loss of wages, loss of extremities, what this poor soul suffered. Let me just read, Mr. Chairman, this comment. Nothing in the Health Act denies injured plaintiffs the ability to obtain adequate redress, including compensation for 100% of their economic loss, essentially anything to which a receipt can be attached. And believe me, plaintiff's attorney will attach every receipt, including their medical costs, the cost of pain relief medication, their loss of wages, their future lost wages, rehabilitation costs, and any other economic out-of-pocket loss suffered as a result of a health care injury. Economic damages include anything whose value can be quantified, including lost wages, home services, au pair, companion to go shopping, medical costs, rehabilitation of a home, access for someone who has an incapacity, an inability to access a normal home. So, you know, the gentleman, just like the gentleman from Iowa, the plaintiff's attorney that spoke on the floor earlier, in regard to misleading statements to suggest that in this legislation we would take away a person like Ms. Palmer of Marietta, Georgia's ability for a full and complete redress of grievances if a medical practitioner or a facility has performed below the standard of care for that local community. My colleague, the chairman of the Judiciary Committee, the distinguished chairman, gave me some statistics in regard to some of the economic losses that people have incurred and judgments that have been awarded by a jury of their peers. Listen to this, Mr. Chairman. In August of 2010, Contra Costa County, a judgment for $5,500,000. Riverside County. These are California cases, by the way, Mr. Chairman. And it's California law that H.R. 5 is based on, MICRA, passed back in 1976. But these are cases in 2010. This one in February of 2010, Riverside County, $16,500,000. November 2009, Los Angeles County, $5 million. October 2009, Sacramento County, $5,750,000. And I'll go down to the last one, although there's several others on the list. July 2007, Los Angeles County, an award of $96,400,000. This, Mr. Chairman, is in 2007. MICRA was passed in 1978. This case in 2007, this plaintiff may have been awarded $250,000 non-economic because there was a cap. But the cap is there not to deny them their day in court, their ability to be judged by a jury of their peers and a decision made in regard to just compensation. There are 21 members of the House GOP Doctors Caucus. It includes 16 physicians, a psychologist, several dentists, several registered nurses. And I'll guarantee you, Mr. Chairman, in every one of these cases that I mentioned coming out of California, we'd be sitting there fighting for those plaintiffs. We would be sitting there fighting, maybe even a witness for the plaintiff, for Mrs. Palmer, to say the sky is the limit. And Mr. Plaintiff's attorney, you tack on every economic cost that you can dream up, and we'll vote in favor of it. But what we are opposed to, Mr. Chairman, is this opportunity for people to come into court and clog up the court system and crowd out Mrs. Palmer in maybe many of these cases from California with frivolous lawsuits where there's no justification for the claim, where people are just hoping with a lottery mentality that some sympathetic jury would just simply say, oh gosh, you know, we know there's no damage here, but after all, the doctor has $10 million worth of insurance. It's not coming out of his pocket. So, you know, let's award the plaintiff $6 or $8 million worth of non-economic pain and suffering, if you want to call it that, damages. That's the thing that's got to stop. That's what's causing the price of health care to rise astronomically. That's why doctors are ordering all these unnecessary tests, practicing defensive medicine. Every time a patient comes to the emergency room with a headache, even though the doctor is skilled in physical diagnosis, in taking a history and examining that patient and looking at their eyes and making sure there's no bulge of the pupils or the optic discs, they know that patient has a tension headache. They know it's perfectly safe to send him or her home with a prescription to return in 24 hours. But no, because of these frivolous lawsuits, they're going to order a CAT scan that costs $1,500. Now, you multiply that time and time and time again. That's what this is all about. That's the problem we're trying to solve. And for my friend from DeKalb, and he is my great friend, or my friend from Iowa, or indeed the former Speaker, the Minority Leader, Ms. Pelosi, to come to the floor and very eloquently, and she is eloquent, it speaks with a lot of passion, great ability, great communicator, but to mislead is downright wrong. The truth needs no adjectives, Mr. Chairman. The truth is what is in the PATH Act, H.R. 5, and I say to my colleagues, we need to pass this and do this in a bipartisan way and not worry here about what's going to happen in the Senate. Let's do the right thing in the House of Representatives, and let's do the people's work. And with that, I yield back.
Gentleman yields back. Mr. Gentleman from Michigan is recognized.
Mr. Speaker, I yield myself 1 minute to ask my friend and distinguished medical practitioner and member of Congress, Mr. Gendry, is he aware that his bill, H.R. 5, eliminates joint and several liability for both economic and non-economic damages? And I yield to the gentleman for that purpose.
Well, I thank the gentleman for yielding, and it gives me an opportunity to explain, and I'm sure the gentleman, it's his time, and I appreciate him yielding, in regard to joint and several liability. Mr. Chairman, it's important for our colleagues on the House floor and anyone within ear shouting distance to understand what we're talking about in regard to joint and several liability. Under current law, anyone who is named as a defendant in a medical malpractice suit is liable for whatever judgment is rendered. It matters not how much they participated in the case. Let me give my good friend from Michigan, the ranking member of the Judiciary Committee, an example. And of course he knows this. Let's say it's an OB/GYN case, and the surgeon who has done a hysterectomy on Friday is going to church on Sunday morning and ask his colleague to stop by and see the patient and to tell her that he'll be around that afternoon to check on her. And the doctor says, sure, I'll be glad to, peeks his head in the door. Mrs. Jones said, I'm fine. Okay, your doctor will be around this afternoon to check on you. Things go to heck in a handbasket. The operating physician maybe has practiced below the standard of care. But that doctor that covered, that peeked in the door, that had really nothing to do with the case, surely, as Mr. Conyers knows, will be named in the lawsuit. And if he or she happens to have the deepest pockets under current law, they could be liable for the entire judgment. Whereas the doctor who practiced below the standard of care, who has a shallow pocket, would get off almost scot-free. So I yield back to my friend, and I thank him for the opportunity.
I yield myself an additional minute, and I thank Dr. Gendry for his response. Did I understand, I asked the author of this bill, H.R. 5, that the answer to my question of whether H.R. 5 eliminates joint and several liability for both economic and non-economic damages is yes?
The answer is yes.
I thank the gentleman very much. Mr. Speaker, I am now pleased to recognize the gentlelady from Houston, Texas, Ms. Sheila Jackson Lee, for as much time as she may consume.
Gentlelady is recognized for as much time as she may consume.
But it's limited to 6 minutes. Don't get carried away. Don't believe
let me thank the ranking member and also the chairman of the Judiciary Committee and the leadership for giving us the opportunity to celebrate, as we debate H.R. 5, celebrate the Affordable Care Act. 2 years in the making. Clearly, it speaks to where we are today. So in celebration of the Affordable Care Act, let me first of all wish it a happy anniversary. And before I start on the Affordable Care Act, let me indicate to my good friend from Georgia and the Physicians Caucus that many of us do not take a back seat to our support for physicians. How can I help myself coming from a community where the Texas Medical Center is? Fighting for a permanent doctor fix, which we have not been able to secure from this Congress, and as well being a champion of physician-owned hospitals, because I do believe that physicians have a high level and acuteness of their concern for their patient. And maybe it is also because in the last decade I've had to tend to ailing parents, both of whom I lost, and have seen doctors up close and personal dealing with one of the most difficult times in any child's life. So this is not about a fight of one side or another regarding doctors. And my constituents have been kind enough to give me time here to have gone through these debates over and over again. So let me just say very quickly, I am glad the Affordable Care Act is in place, because what we're celebrating today as we talk about H.R. 5 is that women will not be dropped from insurance when they get sick or pregnant. Insurance companies will not require women to obtain pre-authorization for referral for access to OBGYN. Millions of older women with chronic conditions will not be banned from care. 279,000 constituents in the 18th Congressional District will have improved employee health care. 187,000 uninsured in the 18th Congressional District will now have access to health care. And my hospitals, my public hospitals, my Texas Children's Hospital, St. Luke's, Methodist, Ben Taub, MD Anderson will be able to secure compensation in uncompensated care. I celebrate the Affordable Care Act. But today we are discussing legislation that has already received a veto notice from the President. But we're here on the floor of the House discussing H.R. 5 and ignoring the fact that the Affordable Care Act has already confirmed health care is vital to America, and we in Congress must protect it. By the way, the Affordable Care Act is a preserver of Medicare. But let me tell you what we are facing with this legislation that is anchored with the component dealing with medical malpractice. We have seen documentation across states that, in fact, medical malpractice is an insurance issue, and even when there is an attempt to, in essence, dumb down the recovery, we have seen that the insurance companies do not, in essence, reward the physicians. Insurance premiums are still high, 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 high. How do I know? You can go to the state of Texas and ask physicians, are their insurance premiums such that they're celebrating today? Yes, there was some measured decline, but they're paying high insurance premiums. Now, in the findings of H.R. 5, our friends cite the Commerce Clause and indicate that Congress has a right to write this bill on health care because of the Commerce Clause. As I understand it, many are pursuing the challenge of the Affordable Care Act, suggesting we had no authority. But in their own bill, the findings cite interstate commerce as the basis of writing this bill. But there are some friends over there that just caught it, and one of the amendments from another gentleman from Georgia strikes the findings. This is to have your cake and eat it too, because they know that tort law has for a long time been the prerogative of states. And so to cite President Reagan when he gave this seminal talk on tort law in 1986, his words, so over the years tort law has helped us drive the negligent out of the marketplace. This in turn has permitted legitimate economic innovation to take its course and raise living standards throughout the nation. The President agrees that tort law drives the negligent out of the arena. He then goes on to say, to be sure, as he put together this task force, much tort law would remain to be reformed by the 50 states, not the federal government. And he says this sentence, and in our federal system of government, this is only right. And so my friends cannot deny that H.R. 5 implodes state law. It takes away the authority of states. And this removing it by some late amendment is not going to make it right. You're going to violate the rights of Colorado, Florida, Illinois, Maryland, Michigan, Texas, and West Virginia that have enacted their own medical malpractice damage caps. You're going to implode the rights of Connecticut, Iowa, New York, Oregon, and Tennessee that have expressly chosen not to limit. And in this bill, if you have not limited it, then you are capped. In this bill, you rid the rights of those states that have not capped. And the flexibility only comes if you have capped and it is higher than what we have, and you obliterate constitutional state law that has its own caps. So this is not as black and white as my good friends would like to make it. We are riding in on the high horse, and we're not. For example, in my state of Texas, Connie Spears, on May 29, 2010, Connie went to a hospital reporting excruciating leg pain. This was an all too familiar due to her previous blood clots. To go on, the emergency room doctor ran tests, discharged her with a bilateral leg pain. But what really happened is that she had blood clots around a vein filter. She got kidney failure. She went unconscious. To save her life, 2 legs were amputated. There was definitive negligence. And it is important to note that she sits today with no legs. What we are suggesting is that we are now intruding into state law, that this individual now under federal law loses non-economic damages for pain and suffering and the extent of the negligence that was promoted, and as well faces a federal hard hat to prevent her from having relief. Now, this is in the state of Texas, and we have tort law reform that many oppose, but it is a state decision. I offered an amendment that would have carved out an exemption for health care lawsuits for serious and irreversible injury, supported by 2 of my colleagues, Congressman Hank Johnson and Mr. Quigley. Exempted victims of malpractice that resulted in irreversible injury, including loss of limbs and loss of reproductive ability, from the $250,000 cap. This was not accepted. What we say today is people like Connie Spears, children, seniors who are limited in their non-economic damages, now have no basis for punishing those who were blatant in their negligence, no way of dealing in a punitive manner to prevent these kinds of acts from happening, and recognizing the loss of limbs of someone who may have been unemployed. My friends cannot have it both ways. That is, challenging the Affordable Care Act because they say that the interstate commerce does not allow us to do good, but yet coming back in their findings to suggest they have the upper hand. Well, I'm going to join my friend on the other side of the aisle, Mr. Johnson, on states' rights. Today on H.R. 5, you literally quash and extinguish states' rights. And in the course of doing so, you quash the rights of injured patients. For those that Ronald Reagan said to get negligence out of the marketplace, out of the care of those who need care, so that the good can rise up. So I'd make the argument that we're now debating in a conflicted manner. I don't know what the positions of Republicans are. They want to get rid of the Affordable Care Act, which was premised on interstate commerce, the authority of Congress. They come right back in our 2-year anniversary celebrating people who are living because of the Affordable Care Act, and now want to place their hat on doing this on interstate commerce. I want to know where all the states' rights advocates are and why you are abolishing and eliminating constitutional state law while you're eliminating statutory law where individual states have expressed their will. I believe this bill, along with the component that wants to dash the Affordable Care Act, is a bill destined for the President's veto, but more importantly, let me try to understand how we can have our good friends on the other side of the aisle their cake and eat it too. I'm celebrating with the celebratory cake of the Affordable Care Act. I don't mind celebrating in this Congress's right to help save lives. How do you put a bill on the floor of the House where you have argued that there is no right for us to be involved in health care? Now you want to dash the rights of those who have been injured through interstate commerce and the Congress of the United States of America. Frankly, the complexity of your argument is such that it makes no sense. And frankly, I hope that my colleagues will join me and applaud the Affordable Care Act, celebrate life that we have provided, expanded life, and also recognize that those individuals who seek remedy in the marketplace who have been injured by negligence and acts that have been dastardly are compensated in a fair and just manner. That is all we ask under the Constitution, due process and the rights of all Americans. I yield back.
The gentleman yields back. The gentleman from Texas is recognized.
Mr. Chairman, I'll yield 2 minutes to the gentleman from Georgia, Mr. Gingrey.
The gentleman is recognized for 2 minutes.
Mr. Chairman, I appreciate Chairman Smith